love Scalia. Yes. Before I actually talk about that, though, a couple of announcements. Firstly, the SSA conference, which I have mentioned to a number of you before, is this summer, July 12th through 14th in Columbus, Ohio. So you should all come. There's lots and lots of really great speakers. There's also a lot of great training for reading groups like this one. The money aspects can be made to work out for whatever your situation is. So come to the conference in Columbus, Ohio, July 12th through 14th. Talk to me if you want to do that about the logistics and carpooling and things like that. Secondly, CFIDC is having its second Women in Secularism Conference, May 17 through 19. There are 5 student tickets left, $50 each. This is also a really good conference. Women is the subject matter of the conference. It certainly skews the audience, but it's open to everyone of all genders. So go to womenInSecularism.org and buy tickets. Ideally tonight, because there's only 5 student tickets left.
It's on the Facebook page, they're sold out.
What? Oh. Okay, that's kind of sad.
And the next price is like 250 tickets, $250.
Yeah, it is.
Yeah.
I checked this like an hour ago.
I checked it this morning, it said they were sold out.
Are you guys?
Either the Facebook page is wrong, or, I mean, that's the only thing I saw.
I'm confused.
The Facebook page.
But we're not going to resolve this right now. We're going to go on to the presentation. Okay, yes. So this is pretty much everything the Constitution says is relevant. As you can see, it's really, really short. The Establishment Clause, Congress shall make no law respecting the establishment of religion. The Free Exercise Clause, for prohibiting the free exercise thereof, which is going to be our focus tonight. I guess just first up, what do people think that means just going in? The free exercise clause specifically. Anyone? Yes.
I think that can say that they can, so long as that doesn't restrict the rights of either other religious sects or the non-religious. And I think that in modern culture that's become an issue. Like people are saying, oh, well, the government can't restrict my rights to disallow gay marriage, for example. But because if we allow gay marriage, that's infringing on the rights of Christians to have marriages between a man and a woman. And that really would be an example of bullying. That's just a matter of imposing your religion, your version of morality over everyone else. So,
Sure.
I think it's a matter of like, how far does that really go?
It's a good general starting point. Anyone else? Okay. Yeah. So, as you can see, the First Amendment says Congress. It originally very clearly did not apply to state governments at all. There were quite a few states that had established churches at the time that the First Amendment was ratified. So we have the 14th Amendment that says that no state shall deprive anyone of life, liberty, or property without due process of law. The courts have said that this applies most of the Bill of Rights to the states, not all of it. There are still a few clauses in the Bill of Rights that don't apply to the states. But the whole of the First Amendment does because of this clause. And then the last relevant part, which the relevance you will see later in the presentation, is Section 5 of the 14th Amendment, which gives Congress the power to enforce all of the stuff that's earlier in the 14th Amendment, which is, it plays into, I'm sure you all remember from high school government probably much better than I do, the part about Congress only having limited powers, the federal government only being able to do the things the Constitution says it does. So 14th Amendment, Section 5 is pretty important to be able to say that Congress can do the things that the 14th Amendment says, as well as the things that are listed in Article 1, Section 8. That was kind of long, but you'll see how it's all relevant later. So the Mormon cases from the late 1800s, these are pretty much the only time before the mid-20th century the Supreme Court ever even talked about the free exercise clause, because really, when is the federal government going to have anything to do with it? And, as I said, it didn't apply to the states until the mid-20th century. So the reason these cases come up is because the Mormons were fleeing to the territories which were still governed by the federal government. So when these things happened in like Utah and Idaho, those were not states yet, so they were still under federal government's control and therefore bound by the federal Bill of Rights. So that's why these cases are coming up here. Reynolds, the U.S. Was pretty straightforward. Government passed a law that says you can't be married to more than one person at once. And the Mormons don't like this, and so it goes all the way up to the Supreme Court, and the Supreme Court upholds the law. Basically, so they draw this distinction between belief and action. You know, the First Amendment, they say, protects the right to believe whatever you want. You can believe in, you know, polygamy, but you can't act on that belief because according to them, polygamy would be absolutely terrible and destructive of society and all these things. So that's kind of the basis of that.
Is that the Reynolds versus U.S.?
Yeah. Yeah, so then a couple of quotes I have up here. One of them says, the only question which remains is whether those who make polygamy a part of their religion are accepted from the operation of the statute. If they are, then those who do not make polygamy a part of their religious belief may be found guilty and punished, while those who do must be acquitted and go free. So this kind of highlights the basic inequality concern that's at the heart of at least my objection to religious exemptions. Religious people should have to follow the same laws everyone else does. If you give religious people the right to break certain laws because of their beliefs, then you're treating religious people or people of a particular religion differently from everyone else in society, and that's not how things are supposed to work in a democracy.
It seems interesting that this is a case where that sort of thing was not allowed, when I feel like in other cases it is. Like, for example, in Catholic hospitals not having to provide contraception.
We'll get there later. Yeah. And then the second quote I have up here, to permit this would be to make the professed doctrine of religious belief superior to the law of the land, and in effect to permit every citizen to become a law unto himself. Government can exist only in name for such circumstances, which I guess is better rhetoric for the same kind of point. The other two Mormon cases that went up to the Supreme Court, Davis versus Beeson, required people who wanted to register to vote to swear that they were not polygamists or members of a polygamous organization, which was again upheld by the Supreme Court. It's a little bit more gray in that now we're getting into like freedom of association, where we're very much going after.
Wait, sorry. Bigamy is two.
Being married to two people.
Yeah. So why would it require voters to swear they're not bigamists?
Well, because this was Idaho and there were a lot of Mormons there at the time.
Oh, this is only Idaho. I thought this was the government saying. This was like the resolution of the court case.
Yeah. So yeah, I'm not entirely sure what the governing structure in Idaho was at the time, but it was under the federal government as a territory, and the government said if you want to register to vote, you have to swear that you're not practicing bigamy or part of an organization that does, and the Supreme Court said that law is okay. And then the last one, late incorporation of the Church of Jesus Christ of Latter-day Saints versus U.S. Basically, the government took all the Mormon church's property and took away their status as a corporation, which is why it says the late corporation.
Okay, so that means that Davis was overturned then, right? Essentially?
No,
Wait, so you can't vote in Idaho unless you're
well, you couldn't in 1890 at least.
Okay, so then you still can't, right? Or can you?
I don't know. I doubt this has come up very recently.
Really?
I mean,
is there like a requirement that you're a polygamist?
That you not be a polygamist.
Oh, that you not be.
Bigamy and polygamy are the same thing. If that was.
No, bigamy and polygamy. Oh, bigamy is two. I thought.
Monogamy. Think about.
Yeah.
Bigamy is big.
Oh,
The
I was
fact that we
thinking
have the
that
word
man and
monogamy.
wife.
Yeah.
Okay.
Yeah, no, bigamy is the crime of marrying someone when you're already married to someone else.
Okay, gotcha. Okay.
Yeah. So all of these are the government doing things the Mormon Church doesn't like, the Mormon Church is doing, and the Mormon Church does. Yeah. And at the end of this, they have basically nothing left, and that is why the Mormon Church today, the mainstream one, is not polygamous. They pretty much surrendered after the last of these cases. So, that's kind of the Mormon cases. What are people's thoughts on that? Those.
I think it's kind of like also making a value judgment though, based on like, no, you can't have polygamy. I mean, not that I say like I am polygamous or anything, I don't really care, but like people should be able to do what they want, I guess. I don't know. I mean, isn't the federal government essentially establishing a standard of monogamy then, which is kind of Judeo-Christian?
Kind of, yeah.
So, I don't know.
Yeah, I think that we can say that it's not like Mormons should just be allowed to marry whoever they want. Everyone should
Right.
be allowed.
Yeah, it has to be a universal
Yeah.
standard.
Yeah. Kind of like Native Americans shouldn't be the only ones allowed to smoke peyote. Like everyone should be allowed to smoke peyote.
Sure.
But the thing is that the Native Americans won't let you. That's the whole point.
What do you mean?
I mean, you have to be like accepted into their like inner circles.
Anyone can go pick a cactus and smoke it.
No, but
You
they
can quote
like
me on
make
that.
it a certain way. Don't they? I think they have to make it a certain way. Peyote
Well,
is like
if you want to brew ayahuasca, then yes.
Oh, I'm thinking of ayahuasca.
Okay,
Ayahuasca.
yeah, we'll get to peyote not too long down the road, but we've got a couple more slides first. Yeah, so as I said, in the mid-20th century, the Free Exercise Clause, along with most of the rest of the Bill of Rights, was applied to the state government. So we now have a lot of cases coming up out of the states. So the first big case on this topic is Sherbert v. Berner, 1963. So basically here, the Seventh-day Adventist woman gets fired from her job because she won't work on Saturdays, which is against her religion. She then goes to the state and asks for unemployment compensation, which the state of South Carolina refuses to give her because she was fired for not doing her job. That goes all the way up to the Supreme Court. And the Supreme Court says that they have to give her the unemployment compensation. So this is, I mean, they analogize it to essentially a fine on Seventh-day Adventists if they don't get the same unemployment insurance benefits as everyone else does, which is kind of weird, but that's what's going on there.
Wait, sorry. They fine the Seventh-day Adventists?
No, the Supreme Court analogizes not giving them the money for unemployment benefits to a fine on being a Sabbatarian generally.
Okay. So they're essentially fining someone for their religion.
Well, that's how the Supreme Court sees it. I mean, South Carolina saw it as this woman was fired for not doing her job. We don't give unemployment benefits to people who are fired for not doing their job, therefore we shouldn't give her unemployment benefits.
Is that how it works in every state? Like, does it matter how you get terminated?
In general, yes, it does. And that's kind of one of the interesting sort of where do you draw the line sort of questions on this. So yeah, some things are legitimate reasons for not doing a job and still getting unemployment benefits. One example is, you don't have to look for work that's outside of your profession. So, lawyers don't have to accept work at McDonald's to still be eligible for unemployment benefits. At the same time, lots of things that you would think would be kind of relevant aren't good enough reasons. So if you've got a kid and you can't afford childcare, that's not a good enough reason to turn down work, at least in South Carolina in 1963. So then the question is, which category is it neutral to put religion in? That's not necessarily obvious. So, I mean, there are arguments for going either way on the particular facts of the case. The test that ultimately comes out of it is a little more broad. So as you can see, the test that the court sets up is that if the government action imposes a burden, and a burden can be quite broadly defined here. If the government action imposes a burden on the practice of a sincerely held religious belief, then the government action has to be narrowly tailored to serve a compelling state interest, which is fancy legal jargon that basically means the government action is almost never okay if it imposes a burden on a sincerely held religious belief, which is very, very broad, potentially.
Which is essentially what's going on here, right?
Right. Yeah, so that potentially exempts a lot of religious people from following a lot of laws. So that's what comes out of Sherbert. Wisconsin v. Yoder is a somewhat even more concerning case. Here we have the problem that Amish people, these are the ones who drive around with horses and buggies and don't use electricity and such. They don't want to send their kids to school beyond the 8th grade, which is also, yeah, So that goes up to the court, and the Amish win disturbingly unanimously. I think part of that is a fundamental flaw in the legal system, in that cases generally only have two sides. So the children weren't even represented in the case. It was the parents versus the state. So, yeah.
Can a child that young represent themselves in the Supreme Court?
I mean, how could they?
Well, there's no reason a court couldn't appoint a lawyer to represent the child's parents.
Yeah.
That has to be the parents. So, yeah, that's that case. I feel like there was more I wanted to say, but it's not coming to me at this point. So yeah, so the remedy for all of this, as I said, in the free exercise area is generally letting the religious people break the law and still applying it to everyone else, which is kind of unequal in sense. So moving on. How am I doing for time? I have no comment here.
7:30.
Okay, and I started really late.
Yeah. you
So-
should get that out.
So Smith. This is the case that the presentation is named for. This fundamentally changes everything. This is the peyote case. So basically, a couple of Native American drug counselors in the state of Washington get fired for using drugs. You would think if anybody could ever be fired for anything, it would be drug counselors using drugs. But no, they have to sue over this. And it goes up to the Supreme Court, and the Supreme Court, 5-4, sides with the state of Washington and says, this is an unemployment benefits case again. They're asking the state for unemployment benefits, and the state said no. And here the court sides with the state 5-4. It does not technically overturn either Sherbert or Yoder, but it pretty much does away with the reasoning and the test that's there in completely incoherent ways. It's a pretty good theory of what happened here is that one of the 5 justices in the majority said that they wouldn't sign on to the opinion if it overturned these previous cases. So Scalia, who is writing the majority opinion here, distinguishes these cases in ways that make no sense whatsoever. So basically, the Seventh-day Adventists can still claim their unemployment benefits, and the Amish still don't have to send their kids to school beyond the 8th grade. But the test that came out of those cases is gone. That the reasoning that was there doesn't really apply anywhere else anymore, which is good.
Kind of racist, though.
What?
It sounds kind of racist, though.
In what way?
Native Americans versus white religions. I mean,
What? You think Scalia would rule more favorably in a case
no,
involving
that's
Christians?
actually totally expected. I wouldn't expect it was.
You may very well be right. Nevertheless, I think doing away with the Sherbert-Yoder test is a pretty good thing. So yeah, quote from Scalia's opinion here: "The danger of anarchy increases in direct proportion to society's diversity of religious beliefs and its determination to coerce or suppress them." So basically, lots of people believe in lots of different things, potentially breaking lots of laws under the previous cases is really bad. So this is, it's appealing to principles of diversity in some sense, which is a nice counter to the other side of the argument. As great as Scalia's opinion here is in some ways, should not give Scalia too much credit. He was not really interested, I don't think, he was not motivated by the religion questions involved so much as Scalia absolutely hates judges balancing interests. He thinks that is work for elected legislators. He's an unelected judge. His job is to follow the rules and to give rules to the lower court judges. And so he doesn't like the Sherbert-Yoder regime, where judges are potentially balancing the state's interest in upholding the law versus the religious minority's interest in practicing their religion. Balancing Scalia is not what courts are supposed to do. So that is what is motivating Scalia here, I think, probably more than racism or religion concerns. But yeah, that's the Smith case. And the test that comes out of that, the key addition in here is that in order to apply strict scrutiny, in order to essentially in any case where you want to find a law unconstitutional, the law has to not be neutral and generally applicable. So the new thing that Smith adds is that if a law is neutral and generally applicable, it's not like targeted at a religion, then it's okay, pretty much. So that is the standing interpretation of what the Free Exercise Clause of the United States Constitution means. Anyone have any more thoughts, responses on that?
So, this guy, like, how do you say his name again? Scalia. If he's not in favor of balancing the interests of the state and the interests of the religious minorities, what does he want to do about that? Like, rather than balancing the interests of not infringing on religious people's rights and the interests of the state enforcing its laws, how else can you approach that problem?
Well, to be clear, his position is that he, as an unelected judge, should not be doing the balancing. He is perfectly okay with legislatures doing the balancing. So if the legislature wants to say that only Native Americans and no one else can use peyote, that's fine. He will uphold that law, but it has to be the legislature that says it, not the courts. This is his position.
Makes sense.
So he's just like trying not to be active. Or trying to be
Pretty much.
kind of. I mean, okay, I guess that's good for this case, but like, it seems kind of like trying really hard to do something that people do all the time.
He doesn't want to set a bad precedent.
That's what he said.
He's trying to overturn it.
Okay, so now that we've seen sort of the two sorts of legal doctrines that pop up in the area of free exercise clause, which do you all think is preferable? I mean, you know what I think.
I don't think either.
Really, and how would you write the law?
I mean, I'm not sure how I would specifically write it, seeing as like there's a lot of cases that can come up, of course, but these in a lot of like both tests, it seems like in a lot of ways infringe on like, I guess, secularism. It seems like, I don't know, like, do you think that's true too?
Well, what do you mean by secularism?
Well, I don't get this one as well as I got the one before. Like, this one is just essentially overturning the last test, right?
More or less.
Okay. What does more or less mean? Is it like...
I'll go on to the next slide and then I'll come back to the question, because you will understand better after that. Next couple of cases, Church of Lukumi Babalu IA versus the city of Hialeah. So basically here, these Santeria people want to come into this town and practice their religion, which involves, amongst other things, killing animals and some combination of eating them and leaving their carcasses at significant places around town. You can understand why the residents of the city of Hialeah are not particularly excited about this plan. So they call a city council meeting and they pass a law that basically prohibits only the Santeria from killing animals. This is very clearly a law targeted at this religion. It is especially clear if you listen to the recording of the city council meeting, where it was very, very clear that the motive here was to discriminate against, to keep out these Santeria people. The city's argued interests here were public health, which did not really stand up as a reason because there were lots of, dumpsters behind restaurants, things that had nothing to do with religion that were worse for public health and that the city didn't even try to regulate. So public health didn't stand up as a serious reason for this. Their other asserted reason was animal welfare, which also did not stand up because the way that the Santeria kill their animals is actually very humane for killing animals. They pretty much slit their throats and they bleed out very, very quickly. So as methods of killing animals go, it's about as good as they come. So the city's asserted interest didn't stand up, and the court says that because this law is targeting this particular religion, it's not neutral and generally applicable, and therefore it's not constitutional.
So this passed, then, right?
So this law was struck down.
Okay.
The Santeria were allowed to come in and practice their religion. Because the law was targeted at one religious group. It was not neutral and generally applicable.
Oh, okay.
And that is the last time that the Supreme Court has ruled on that particular issue. The second case I have up here is from the Third Circuit, which is the level of court below the Supreme Court. The opinion was written by Judge Samuel Alito, who has since been promoted. So the issue here is Islam, or specifically Muslim men, are required by their religion to have beards of some kind, and that conflicted with the policy of the police department of the city of Newark, New Jersey. So this goes to the Third Circuit, and the Third Circuit says that because the police department will grant an exemption for people with a certain skin condition based on the Americans with Disabilities Act, that therefore it can't be too important to the functioning of the police department for the cops to not have beards of any kind, and so the Muslims have to get an exemption too. So this case reads neutral and generally applicable to mean that if anybody gets any exemption for any reason, then religious people have to get an exemption. As I said, this is not the Supreme Court. This is the Third Circuit. Other courts at the same level of the court system have said opposite things. The Supreme Court has not chimed in on this yet. So what neutral and generally applicable means depends on what part of the country you're living in, what circuit court has jurisdiction over you. So that's sort of where neutral and generally applicable ends up. Does that clarify at all the Smith test, or have I just confused you more?
No. This is like kind of unrelated. What are the borders of the Third Circuit?
The Third Circuit covers Pennsylvania, New Jersey, and Delaware.
Okay, so
We're in the Fourth Circuit.
okay. Just wondering. Just haven't gotten the circuit court before. So.
Yes,
Okay.
I have no idea what the Fourth Circuit has said on this subject. I have not looked it up.
Do you know what other circuit courts have said on the subject? Or is this just like the most important one?
Yeah, I don't think this is any more important than any other, except insofar as the judge who wrote it is now a Supreme Court justice. But other circuits have definitely read neutral and generally applicable much more narrowly, basically as saying that the law has to be more or less intentionally targeted at a particular religious group in order to not be okay under the Constitution. So what do you think now about these different tests and whether they conflict with secularism and so forth?
I guess they don't. The second one doesn't as much. Because you clearly so neutral and generally applicable is in the second test, right?
Yeah.
Okay.
Those words come straight out of the Smith opinion.
Okay. Then yeah, these seem to be fair. So.
Because
aside, from this minor controversy, I like the criteria.
Yeah.
I think they work well.
What?
I think they work well.
Okay.
Yeah, because I mean, it lines up nicely with like, no like specific discrimination within, like to any particular group,
Right.
like with the homosexuality cases.
Right.
I would assume that it is a two-way street, and like it's been working that way. Like in terms of like in one direction, it prevents religious practices from being like infringed upon or stamped out by certain laws. But at the same time, it should also mean that religion can't get any privilege or exemption from having to follow certain laws that everyone else would have to follow. So I guess we'll get to that.
Is there anybody who prefers the Sherbert-Yoder version?
Are there reasons too, like besides the general principle?
Isn't the main difference between that like belief versus practice?
Yeah. I mean, certainly under either test, the government can't make believing X a criterion for anything. The Sherbert-Yoder thing sort of does away with the distinction between belief and conduct and says it's all protected by the free exercise clause to the same extent. And the Smith stuff says, I mean, it still says the government can't use belief as a criterion for anything, but so long as the conduct requirement is not about the particular religion, it's okay. Smith, or under Smith. So, so that definitely brings the distinction back to a significant extent. Yeah. Yep. Okay. You all are much more sane than most members of the United States Congress. So
We don't have pounds and pounds of political baggage weighing on our decisions and our
yeah, you don't need the religious people's vote for anything.
exactly.
Yeah, that's true.
Yeah. Yeah, so Smith, as we said, was 1990. In 1993, Congress passed the Religious Freedom Restoration Act, known as RFRA, which basically reinstated the Sherbert-Yoder test as a matter of federal statutory law. So it said that any law by either the federal government or a state has to stand up to the Sherbert-Yoder test. It has, if it imposes a burden on religion intentionally or not, it has to serve a compelling government interest and be narrowly tailored to serve that interest. As far as the federal government, Congress can obviously impose whatever restrictions it wants on its own laws. As far as the state governments, it was relying on Section 5 of the 14th Amendment, which says that Congress has the power to enforce the Due Process Clause, which applies the Free Exercise Clause to the states. That was the basis of Congress's power in the Religious Freedom Restoration Act. So that goes up to the Supreme Court in the city of Bernie versus Flores. Yes, it is pronounced Bernie. I have no earthly idea why, but it is. So that case was about land use. Catholic Church wanted to expand. The city says you're building this an historic landmark, you can't expand. And so that goes up to the Supreme Court, the church invoking the Religious Freedom Restoration Act as its basis for saying, you know, if we can't expand our church, that's a burden on our religion. And the Supreme Court says that Section 5 of the 14th Amendment gives Congress the power to enforce the Free Exercise Clause against the states, but only what the Supreme Court says the Free Exercise Clause is, which is the Smith test, the Sherbert-Yoder test. So this case invalidates RFRA as applied to the states. So the Federal Religious Freedom Restoration Act does not apply to laws of state governments anymore. It still does apply to laws that are passed by the federal government.
Wait, but didn't it start out in the state, or did it start out federal?
This was a federal law passed by Congress.
Okay. So, which state was this? It was trying to
Bernie versus Flores. I do not remember off the top of my head what state that was in.
Okay, so that what the logic is they're trying to apply free exercise to the states, but with the Sherbert test instead of the Smith test.
Right. Right. So Congress was telling the states that you have to follow the Sherbert test. It was invoking it was claiming a power to enforce the free exercise clause against the states that the 14th Amendment gives it. The problem was that the Supreme Court says that the free exercise clause means Smith, not Sherman.
It's probably Florida.
What?
It's probably Florida.
Could be Louisiana. Just leave it to the church.
Do people follow that reasoning?
I'm starting to think I don't really understand the difference between Sherbert and Smith as well as I thought I did.
Okay.
I thought it was just I thought it was just a matter of like your sincerely held religious belief would be Sherbert, and then like your actual like sincerely practiced belief. Did the neutral and generally applicable clause only come in for the Smith test?
Yeah, neutral and generally applicable is only for Smith.
So then for Sherbert, it wouldn't include that clause. It would
Yeah,
just
for
be-
sure. Which usually means it's unconstitutional.
Could you even argue that this is, even under Sherbert, kind of a weak case? Because if it's a historic landmark, that has to do with civic things. I'm sure a lawyer could make the argument.
Somebody
But-
probably could. It would probably lose. Do we really think that preserving one historic landmark is a compelling government interest?
I do.
And that's the thing about the Sherbert test. It's not weighing the religion's interest against the general interest in preserving historic landmarks. It is weighing the religion's interest against the government's interest in preserving that particular historic landmark, which is a much
can't be
harder argument to
specific.
case.
Yeah, so it can't be specific. Yeah, Sherbert's kind of like a bad resolution because it's not
Yeah.
even really doesn't even say anything.
Yep. Yep.
No, I kind of like it as a federal standard, though.
Why?
It's so vague. It doesn't solve hardly anything.
Why do you like it?
Well, it seems like it's more restrictive on the federal government's ability to impose like national standards on behavior, which I think is just a good thing for the federal government to decide. Like, not necessarily constitutionally we shouldn't have Sherbert. I like that. I like the Smith test for like the Constitution, and I like that that's what the states have to go by.
So just a general.
I kind of think that this turned out like the best way possible, which is
Okay.
that the states have to abide by the Constitution, but the federal government can have its own standard that doesn't apply. Like, they can't strong arm the states into going along with it as well.
We'll see if you still think that at the end.
I don't know. I think in
Story's not
theory
finished
that's
yet.
like a very well constructed system, but
Yeah. I mean
we'll see what happens.
Yeah, I mean, aside from the rest of the story, I mean, because RFRA is just a law passed by Congress, it can be overridden by just another law passed by Congress.
Yeah, which is what Scalia had in mind, right? He said
Yeah.
like the
Yeah.
balancing act would take place in legislature,
Right.
and that's
Right.
basically what happened.
Right. Okay, so moving on to the next thing, the Religious Liberty Protection Act. So this is basically Congress looked at what went wrong with the Religious Freedom Restoration Act and it tried to fix it. So it wrote a law basically applying the same standard but relying on the spending power and the commerce power. So saying that the Sherbert-Yoder standard applies to any state program that is taking any federal money or to anything that affects interstate commerce, which is going to be most things. This law failed. The difference, I think, was as much a matter of timing as anything. So after Smith, lots and lots of people were unhappy with the Smith ruling. This includes, by the way, the Americans of the Liberties Union and Americans United for Separation of Church and State, as well as all the right-wing people. All of those people wanted the Religious Freedom Restoration Act, which is kind of disturbing. But by 1998, we have the gay rights movement, and that causes it all to fall apart. So the issue that they were concerned about is where it goes up against discrimination. So they were particularly concerned with landlords that didn't want to rent to gay couples. In some states, there were laws that said they had to. But if you've got something like the Religious Liberty Protection Act, then the landlord can say, well, my religion says homosexuality is a sin. I can't rent to gay couples. And So that's where the conflict came in there. And so by 1998, we have the gay rights movement opposing this, and it all falls apart, and the law comes. So that's where federal law has ended up. The state, a number of states have passed their own versions of RFRA in their state legislatures, which is obviously valid. A state legislature
Who's
can.
Virginia?
I have no idea. Some other states have courts that have interpreted their state constitutions to mean something closer to Sherbert-Yoder than Smith. So in about 31 states now, we still have essentially a Sherbert-Yoder standard applied to state law as well as federal. That's because of decisions that were made at the state level and therefore can be undone at the state level if people want to do that. So that's more or less where the law has ended up. The last piece of this is the Religious Land Use and Institutionalized Persons Act. So after the Religious Liberty Protection Act failed, Congress wrote this thing which only applies to land use decisions and people and institutions, which is usually prisons. And this, again, applies the Sherbert-Yoder standard, essentially, to those two sets of cases across the country. But it's just those two areas. And since neither of those really has implications for civil liberties or gay rights or anything like that that anyone can really think of, that wasn't really opposed so much, and that passed. So that's the end of where the law is now.
Wait, what does it mean, religious land use and institutionalized person? Like, can like go into a prison and murder people, or what?
So the land use part is, zoning decisions, building of churches, things like that. So that gives religious institutions a leg out on that stuff. The institutionalized persons.
Wait, what's an example of that? Like, as in, like, someone, like, trying to buy a business, or, like, lease something, and someone else wants to make it a church?
Well, I mean, as I understand it, land use, if you want to build something, you have to get approvals from the local government, and that's a very subjective process. There aren't very many standards for that, and so local governments that don't want new churches to come in and build, which they often do not, can come up with some reason about traffic flow or something like that to not let the church build. So this gives churches a way of coming back and building their building. Okay, so that's the land use part. And then the prison part, I mean, that can be something like the Jewish prisoner wants kosher meals.
And so they're saying, like, you have a right to that?
Yeah.
Okay. What about, domain,
Doma.
not doma, eminent domain, yeah.
Eminent domain.
Does that everything, what if that gets all turned down? Religious land
How would
use?
that happen?
Like federal domain,
Eminent domain.
eminent domain says, like, you need this land, and it has a church on it.
So you need this land, and so the government wants to take land that has a building, that has a church on it, and build something else on it.
Yeah.
I do not know the answer to that, so I'm just going to move on. That's okay.
Okay, yeah.
They'll probably just do it anyways, because they do it for private businesses.
No, I'm just wondering if this applies.
Right,
or...
but if Arlupa applies, that could potentially give the church a legal leg out that a business wouldn't have, and I'm not sure how that would come out.
I'm sure it'll happen sometime.
It probably has, and I just don't know
Oh,
about it.
okay. Maybe.
That's a good question. So moving on. So the general issue of...
Oh, I just
I think
skipped.
you skipped.
Oh, I did. Let's go. There we go. Okay. So yes, exemptions versus civil rights. So just yesterday, a court in Hawaii had a case where some bed and breakfast owner didn't want to let a lesbian couple stay there because this person didn't thought homosexuality was a sin and all that. So that violated a Hawaii civil rights law, and the Hawaii court said that the civil rights law stands, but that's the kind of case where civil rights runs up against these kinds of religious exemptions a lot. So you've got that with, you know, the bed and breakfast owner. You've got that with the wedding photographer who doesn't want to take pictures of a gay wedding. You've got that with, you know, the city clerk who doesn't want to sign the marriage certificate for a gay couple.
And just last week, something like that happened in Washington State. There was a florist who she'd been selling flowers to a gay couple for years, and they were finally going to get married because it had become legal in Washington to do so. So they wanted her to like do the flowers for the wedding, which is very different from just selling flowers. She just has to like plan it out, be very intimately involved in the ceremony.
Right.
She said she didn't want to do that because of my relationship with Jesus Christ. And they took the case to court and came back and said she would have to provide the service. If she provides it for heterosexual couples, she has to provide it for homosexual couples.
Right. Yeah. Now this is all coming up at the state level because federal law doesn't protect homosexuals from discrimination pretty much in any circumstances. So it's all coming up in those states that have state laws that prohibit discrimination on sexual orientation. So it's all being decided in state courts on state law, and the outcomes are varying from state to state, but these are the kinds of things that are coming up there. So does anyone have any thoughts on this clash?
Yeah, so like, why can't the federal government do something about that? Like, why is it up to the states to make sort of like laws of like homosexuality?
If Congress wanted to pass a law prohibiting discrimination on sexual orientation, they could. They just haven't.
They're coming under pressure to decide one or the other.
What's Hosanna to War versus the EEOC?
That's another case that the legal grounds for that case are somewhat different, and I'm not going to go in there because that's a whole separate line of cases. But it's very much the same sort of conflict between civil rights laws and religious people wanting their own rules. So basically what happened in this case, we have this elementary school teacher, I believe she was a fourth grade teacher at a Lutheran school. She takes a leave of absence because some disease. She's protected by the Americans with Disabilities Act, or at least would be, you know, in any, if she were employed by an institution that wasn't religious, it's very clear she would be protected by the ADA. So, you know, being a teacher in the Lutheran elementary school, you know, there comes a point when she's ready to come back, and at that point the conflict erupts and she threatens to sue, which according to the Lutheran Church, apparently, and you can decide for yourself how seriously you think this is as a religious belief, but the Lutheran Church believes that disputes should be resolved within the church and not taken to the civil court system at all. So just making the threat was, you know, a violation of the Lutheran faith, and so they fired her based on that, and that goes up to the Supreme Court last year.
It's hard.
Yeah. Yeah. And so the Supreme Court rules, and this was disturbingly quite unanimous, that for a ministerial employee, which the court says Ms. Perrick, the person in the case, was a ministerial employee despite being a general fourth grade teacher. For a ministerial employee, federal civil rights law just doesn't apply. They can discriminate on whatever they want federal civil rights law. And civil rights law generally is not going to restrict that. So even if your state has a law that says you can't discriminate on a particular characteristic, churches, religious institutions still can for their ministerial employees. So this means, for example, that if a church fires its minister because they don't like the color of his skin, that is legally okay. The minister will not be able to sue.
And this applies to all states? This is like federal?
Yeah, this is as a matter of interpretation of the establishment and free exercise clauses. There's still a sort of open question about whether it will apply to contract law. So if in the employment contract between the minister and the church, it says the minister cannot be fired because of such and such characteristics. Is that legally valid? And that's, the Supreme Court specifically said that that was beyond the scope of the ruling. It wasn't deciding that, so that's an open question.
Has that ever been put in any ministerial contract?
I have no earthly idea.
I mean,
I'm
that would
sure,
be
I'm sure
really-
someone will now.
That'd be impressive.
If it hasn't happened, if it hasn't been in one before, I'm sure it will be now. So that's another case where civil rights law versus religious people wanting to do whatever they want. So does anyone have any thoughts on all of this? To what extent do you think civil rights law should be overridden by religious people's beliefs or not?
Pretty far.
Every case.
I mean,
Really all these.
at the same time, I mean, the Catholic Church bars women from the priesthood. So
It does.
it's-
And this was one of the really big things that was on the table. They were worried about how not to tell the Catholic Church to ordain women.
I mean, it's. I feel like it really would be restricting. It would be going against the free exercise clause to tell a religious institution that they have to include such and such kind of person in their ministries if that is against their religion. I mean, because then that's not a matter of. It's specifically like entering into how they're running their religious practices and telling them you have to do this a certain way, even if it's against their religious beliefs. But then the other side of that would be, at what point does it become an issue where this religious institution is restricting somebody's civil rights? Does somebody have a civil right to taking a certain job within a religious institution? I think
Well, we say generally people have a civil right not to be discriminated against in employment on the basis of certain characteristics like race, sex, religion. Why? If it sounds like you're saying that religious institutions should be different from other institutions for those purposes. Why would that be?
that is one aspect of my whole
Yeah.
thought process that I had
Yeah.
jumped ahead of.
Yeah. And I mean, I guess the sort of standard argument is that that's a much more personal relationship than most employment relationships. You know, the extent to which people trust their ministers and are intimate in their relationships with their ministers is much greater than most employment relationships in society. And so that's an interest thing.
Not only that, but I think that in any case, well, in most cases, I guess, like the Hosanna case, it seems like if they wanted to fire her, or if they didn't want to hire someone based on some sort of characteristic, and the Supreme Court turned that down and said, no, you cannot discriminate based on, I don't know, like gender or something. The church would find another reason or some other way to make sure that specific people didn't get hired in their establishment. So,
Right, and I mean, that's a general problem in employment law. You know, people who don't want to hire blacks, for example, can
So
often
they don't qualify. Yeah.
say they're doing it for other reasons, and courts in general are able to look into the facts and decide for themselves whether or not they believe the reasons that the employer is giving.
right, so if we have that same standard for every other place of employment, then, and people still manage to get around that, I don't see why we treat this any differently, seeing as people will still find a way to get around it. Like, in terms of like, I mean, not that that's really a reason.
Well, I mean, a lot of times people don't get around it. Courts will say, sometimes
sometimes
states
they-
a certain employer, they're bullshitting us.
Yeah, no, that's true. I mean, they'll find some other way. I mean, yeah, sometimes you can't bullshit it, but definitely in some cases they will find some way to bullshit it. So, not that that is an arguable reason to put a law in place, but in the grand scheme of things, how much of a difference does it really make? It could make a big difference, but it won't make as sweeping of a difference as the church probably thinks it will.
Well, I mean, in the Hosanna Tabor case, I think the facts were pretty clear that, you know, if there hadn't been a special rule carved out for religion, you know, she would have had a perfectly valid ABA claim. she could have been awarded damages under the Americans with Disabilities Act. So I mean, there are definitely cases where employment law works, where
Yeah, I'm not saying that. I'm not saying it's like all futile or anything. I'm just saying like
I
we're really
just-
skeptical about it. Yeah.
yeah, I don't know what the numbers are on employment law cases. I don't know. I'm not even sure how you measure something like that.
Is there?
That's a good question.
I'm sorry.
No.
Go ahead.
Is there a way that the federal, like the Supreme Court, could somehow establish whether civil rights precede the non-establishment clause? Like
This is free exercise clause.
for the free exercise clause. Would there be some way, some standard that they could uphold that says this is where the line is drawn, where people can practice their religion freely up until the point of infringing on people's civil rights? Is there any sort of law that could be made to establish that?
Well, I'm with the under Smith, the Constitution itself. I don't think it's going to run up against civil rights all that much. I mean, the Hosanna Tabor case that did, it's kind of weird. As I said, that's actually a separate sort of legal line of cases that was decided under. But yeah, under the free exercise exemptions issue in general, I don't think there's going to be that much clash, just because there's very few times that the free exercise clause says that there have to be exemptions. So that leaves it all to either Congress to decide, if it's going to protect civil rights of some kind, whether it's going to carve out an exception for religious people. As I said, there are, and sometimes it has. So in the employment context, the Hosanna Tabor says says that churches can discriminate on anything with respect to their ministerial employees. There is a separate clause in the statute that was written by Congress that says churches can discriminate on the basis of religious belief only with respect to any of their employees whatsoever, ministerial or not. So Catholic Church can insist that its janitors be Catholic, even though that has absolutely nothing to do with the job of sweeping floors. And that's perfectly valid. That was upheld 9-0 by the Supreme Court in Corporation of the Presiding Bishop of the Church of Jesus Christ of Latter-day Saints versus Amos. So yeah, that's a matter of Congress passing laws and then the Supreme Court interpreting them. At the state level, which, as I said, is where a lot of these come up. If you've got a state Religious Freedom Restoration Act versus a state Civil Rights Act of some kind, ultimately, or versus a state constitutional provision, that's going to be decided by the state courts. As a rule, the federal courts defer to the states on the interpretation of state law. So that's not even for the federal government at all.
Has there ever been a case where a place of employment requires, for example, their employees to be like black or white? I mean, in the basically since probably 1980.
Has there been? As a matter of practice, I'm sure, for example, African American churches will insist that their pastors, who are probably, in most cases, their only employees, be black. I'm sure there are other churches in the South that would go the other way.
Yeah. Or that way, even.
Yeah.
Casting for television, film, commercials, often they'll want a specific person to meet, like not just like a racial thing, but like you have to be this tall.
Oh, but that's valid. Like,
I
mean,
like it's, and they're allowed to because it's like your ability to perform the duties required rests upon like your physical appearance. because we need to sell like a certain image because of like artistic license and things like
Have you
Yeah,
ever-
no, it's totally fine. It's just a
Yeah.
license, but that doesn't have anything to do with like.
Like Abraham Lincoln needs to be white in this movie. Sorry.
Yeah, I mean, certainly you can, that's actually, there's actually a third exception to employment non-discrimination law called the bona fide occupational qualification exception, which basically says if it's really, really, really required for the particular job, then you can discriminate on, this characteristic that's really, really, really required. And I think requiring the actor who plays Abraham Lincoln to be white or the actor who plays Thurgood Marshall to be black, I think would both fall within that
Of course.
exception.
But then it's not like a huge stretch to say that the Catholic Church can decide to only hire Catholics to certain positions. And then if you don't meet
you
a
can't credibly
standard,
play Abraham Lincoln if you're not white and tall and thin. You
But
can sweep the floor of the
It's not
Catholic Church
necessary
without
or
being
sufficient.
Catholic. Can't?
yeah, maybe. Well, let's put aside the fact that I disagree with civil rights legislation's ability to tell people what they can and cannot do.
Really?
Yeah, I think they should only apply to governments. But let's put that aside for the moment. I think that we have the Establishment Clause. I mean, the Free Exercise Clause. We
Yes.
have, and it refers to religion specifically. So whether we like it or not, there is a distinction between the actions of a private citizen based on their whims and the actions of a private citizen based on their religion. There is a legal difference there, right?
Arguably. I mean, to the extent that even under Smith and Likumi, there's certainly protection against discrimination on the basis of religious belief. That's very clear. It may go farther. It's not so clear. But I mean, that could certainly be analogized to something like the Equal Protection Clause protecting people from discrimination on the basis of race.
Yeah.
A clause that tells the government not to discriminate on a particular characteristic isn't necessarily privileging people who are, religious or black or
Yeah.
whatever else.
But it seems like we might need to clarify what counts as a religious opinion or what counts as a part of a religious ideology. Like the idea that you should keep matters inside the church and not go to the government is not something that I've ever heard of before, and I know plenty of Lutherans. So that sounds like a bullshit justification for basically non-controversy within the church, which is not a valid religious principle. So I think that it's kind of strange that they treated it like it is, and it's kind of strange that they upheld the termination of this woman.
Well, I think there are two sort of concerns there that they had. One was if the courts start asking that question about what's really a religious belief and what's not,
Yeah.
that's sort of intruding into the area where they have to start interpreting theology, and they really, really don't like to interpret theology. And two, I mean, I don't know how many Lutherans would be aware of that rule, but it's certainly been written down in Lutheran documents for a long time, taught in Lutheran seminaries for a long time. So it's not like they've just made it up for litigation.